My name is Oryanna Parrish Ward. I am from Dothan, Alabama. I am 37 years old and I have 3 beautiful daughters. On April 17th of 2011, DHR took my children absent exigent circumstances and with no court order. A third party claimed that my 7-year-old daughter accused my boyfriend of touching her inappropriately. Without first speaking to my daughter or myself, Wanda Sanders, the on-call DHR worker, made the immediate decision that my children were not safe in my care. I was coerced into signing a safety plan, almost with no explanation. The DHR worker told me if I did not sign it, my children would be placed into state custody that very night. At that time, I had no idea of the power that had been given to that state agency, and I felt I had no other choice. I requested a physical exam that night, but was told by Wanda Sanders that there was no need to rush it. I talked to an investigative worker, Sandy London, the next day. I inquired about the return of my children, and she stated that as long as the accused remained in my home, they would not be returned to me. I assured her he was no longer in my home. She said she would have to make a home visit to verify that, yet she never did. All 3 of my girls were interviewed at the Child Advocacy Center without my consent and with no court order. The interviewer, Marie Johnson, questioned my 7-year-old for 45 minutes, and my daughter repeatedly told her nothing had happened. She insinuated that my daughter was lying and continued to question her. My other 2 girls were questioned for 10 minutes and answered the same questions the same way. They were dismissed. My 2 youngest were examined with no consent and no court order. The results of both exams were inconclusive. DHR still refused to return my children. I was accused of being on drugs. I immediately submitted a drug screen and was negative. I was accused of not taking my girls to the doctor and produced 3 current shot records, and DHR would still not return my children. There was never a home visit. I was never interviewed by anyone from DHR. These are both violations of DHR's policies and procedures under Alabama Administrative Code. During the times that I visited my daughters at the babysitters, which they were placed on a safety plan, they were being neglected and the babysitter was abusing her own son. I reported this to DHR and it was never investigated. They remained in her care for 3 weeks. The lawyer I obtained, Thomas Smith, sent DHR a letter on May 4th recommending they return my children since they had provided no valid reason for keeping them. DHR referred to this as a threat from me and immediately filed a petition for custody. They later referred to this as a violation of the safety plan. My first court hearing, which was May 6, 2011, there was no evidence presented to the judge of me being unfit. I was not given an opportunity to defend myself in any way. Yet the judge gave temporary custody to DHR. The allegation against me at that time was failure to protect my children. I repeatedly explained to various workers at DHR if indeed anything inappropriate was going on in my home, there were no signs and I was unaware. Therefore, how did I fail to protect my girls? Of course, I received no logical answer. On June 28, 2011, I received a letter from DHR stating that I had been named in the abuse and neglect of my 2 youngest daughters by taping their hands behind their backs for not picking up their toys. I did not do this, their father did. I tried to tell DHR that, but he was never questioned. I was indicted for child abuse in August 2011. I was found not guilty after my 5th time on docket on October 3, 2012. I went to DHR to ask that they return my children since I had been acquitted, and I was told by DHR that my charges were not the reason they were originally taken from me. I had 1 hour supervised visits with my girls from June 2011 until March of 2012. During this time, there were many visits when my children would cry to come home and cry because they missed me. I reported this behavior to DHR, but it was never written in their report to the court. Most of these visitations, DHR worker Lynn Jones supervised. She overheard my 7-year-old on one occasion state at a visit, "I don't want to go, I want to stay with you, Mama." Miss Jones denied hearing that at my trial. In April of 2012, my children's therapist, whom I had never met, submitted a letter to the judge asking to suspend visitation due to hearsay from relatives of inappropriate conversation. I had recorded all of my visits and offered this to DHR, but they refused to listen to any of them. The judge ruled to suspend my visits. I have not gotten to spend any time with any of my girls since March 28th of 2012. On September 6, 2011, DHR and the guardian ad litem suggested that my oldest daughter be placed with her father, even though he had tested positive for methamphetamines 3 months earlier and had a long history of marijuana use and domestic violence against me. The judge allowed placement, and 2 weeks later, my daughter showed me bruises on her arm that her father had caused. I reported this, and it was never investigated. She was, however, removed from his home. Since the start, I have taken a total of 6 drug tests, all of which were negative. 1 was a hair test. I have taken parenting classes, a psychological evaluation, which there was no diagnosis, and have been going to counseling for over a year, yet DHR refuses to even entertain the thought of returning my children to me. On June 19, 2012, all of my girls were placed in the legal custody of relatives, even though there was no evidence of me being an unfit mother, only hearsay by people that were unwilling to testify. My children's rights have been violated, as well as my own constitutional right as a parent to raise my children without government interference, absent clear and convincing evidence of unfitness. There were no reasonable efforts prior to removal and have been no efforts toward reunification.